Modern legal systems are highly developed. They contain constitutions, courts, procedural safeguards, international treaties, and administrative structures designed to protect individuals and resolve disputes. And yet, certain cases remain unresolved for years, not necessarily because institutions act unlawfully, but because multiple legal systems, jurisdictions, or procedures become structurally incompatible. This is the problem explored by the exceptional court proposal. In some exceptional situations, every institution may act correctly, every procedure may formally function, and every authority may remain within its legal competence. Yet the individual remains trapped in prolonged legal uncertainty. This can happen in statelessness cases, cross-border family disputes, identity conflicts, nationality problems, and situations involving fragmented institutional competences. The problem is not always corruption or bad faith. Sometimes the legal system itself becomes procedurally fragmented. Different jurisdictions require different things. Administrative systems cannot coordinate effectively, and ordinary procedural mechanisms become incapable of producing coherent resolution. The exceptional court proposal emerges from this structural reality. The exceptional court is not designed as a revolutionary tribunal or a replacement for ordinary courts. The framework instead proposes a specialized first instance jurisdiction integrated into the constitutional judicial system of the state, operating only subsidiarily and exceptionally. The court would examine whether ordinary legal mechanisms have become objectively incapable of resolving a structurally exceptional legal situation. The framework includes admissibility review, proportionality safeguards, constitutional restraint, comparative legal examination, and ordinary appellate review. Comparative law is not used to replace national sovereignty. Instead, it functions as a judicial methodology for addressing cross-jurisdictional incompatibilities and structural legal deadlocks. The proposal repeatedly emphasizes judicial restraint, constitutional hierarchy, and preservation of ordinary institutional competences. Modern legal systems increasingly interact across borders. Nationality, migration, family law, administrative recognition, and identity issues often involve multiple jurisdictions simultaneously. But procedural systems were not always designed for this level of legal interconnection. The exceptional court proposal therefore asks a broader question. What should a legal system do when ordinary procedural mechanisms remain formally available, yet practically incapable of resolving an exceptional legal situation? The current draft does not claim to provide a final answer. It is instead a working legal proposal, a comparative procedural experiment, and an invitation for further academic and institutional discussion. The full draft framework and supporting materials are available on law-clinic.eu. For more information, read the full draft on the link in the description. Thank you for watching.